Where were we, Mr. Nolan?
Well, lady, I was just going to finish, if I may, one point about the ground one, and that was to do with the sibling relationships. We've set out at paragraph 16 of our submissions, and that's CB, or I should say it's the core bundle A51. It's paragraph 16, where we've set out a chronology, the dates and times where the children were together.
Sorry, paragraph 16.
Paragraph 16.
Oh, yes.
To counter the suggestion that there's nothing in this case to mark out the sibling relationships as being, as the local authority say, an obvious foil to adoption. We've simply set out there the development of that sibling group over time, and then referenced from the social work sibling relationship assessment over onto A52.
Thank you.
Lady, then, unless there are other matters I can assist specifically in respect of ground one.
No, thank you.
No, thank you.
And ground two, so that is at A19 of my learned friend's submissions on behalf of the local authority. The suggestion that the judge was wrong to refuse placement orders on the basis that the mother could not be completely ruled out. So, first of all, what we say is that that is not the real reason that the judge did not make placement orders. At paragraph 44 of his judgment, and that is B15, the core bundle. It's the penultimate, rather the last three lines. And he says there, I have to consider H and A's lifelong welfare. In that contact, it may be in that context is how it should read. The sibling relationship assumes a critical importance. Its maintenance simply cannot be guaranteed in adoption, certainly not to any meaningful level. So we say that is the key to why the judge did not make the placement order. It's absolutely right, as my learned friend sets out in his submissions, that the judge had many critical things to say about the mother through paragraphs 33 to 36 of his judgment. He recognised what the local authority had done to support the children's return in 2003, and he subsequently identified the failures of the mother, which of course led to the second set of proceedings. But the court should then look at paragraph 32 of the judgment. This is at B11, because we submit what the judge was focused on when it came to the mother was what she could provide through her relationship with the children, not necessarily one of caring for the children. Paragraph 32, there's a close emotional bond between each of the children and the mother. Contact has been good. The mother's able to manage the competing needs of four very young children. What is clear through the evidence of the local authority, it's clear in what was agreed in terms of the threshold, which is earlier in the judgment, is that the mother had proved incapable of looking after all four children when they were returned to her care. And it's that the judge rules her out as one of those realistic options in paragraph 35, I think it is. He rules the mother out. So he's not focused on the mother being able to care for the children as a real factor in refusing the making of a placement order. And when the court considers the judge's reasoning, at paragraph 36, This is on B12. Paragraph 36, it's the last 4 lines. All 4 children clearly benefit from the contact they have with the mother. All clearly have memories of their parents of equal, if not greater importance. All 4 have a close bond with each other. All benefit from their relationship with each other. At paragraph 37, the judge continues, the sibling relationship in this case is likely to outlast relationships with the parents. And the closeness in age of the sibling group means that these relationships are likely to endure for the rest of their life. It's those relationships which the judge is then indicating that long-term foster care can maintain. So throughout that reasoning, what we would say is it's not the fact that mother may in due course resolve her emotional psychological issues, as the judge speculates at paragraph 45, that has put the brake for him on the making of a placement order. He has been focused, we say, on the sibling relationship, notwithstanding that there is, and it seems to have been accepted, an ongoing benefit in the children's contact with their mother.
Well, in 45 concludes, adoption in this case is neither necessary nor proportionate, and any advantages in terms of permanence are outweighed by the loss of the sibling and parental relationship. To my mind, long-term fostering is the most proportionate means of meeting the children's welfare needs, and it guarantees the preservation for the children of sibling and parental bonds. I emphasise those words.
He's clearly recognising, and he does throughout the course of the judgment, that despite her difficulties and her failings, the mother has been able to provide a beneficial impact on the children through contact.
So it is a part of his thinking, is it?
Yes.
That part of his reasons for rejecting adoption and favouring long-term fostering is that it will enable the relationship to continue with the mother.
Part of the thinking. Because it's clear he's
not the prospect of the prospect of rehabilitation, but
no.
continuing the relationship.
Yes, because that's what the mother has been able to commit to, recognised, I think, both by the local authority and the guardian, as a positive. The local authority's care plan was the maintenance of monthly contact for the mother, pending the identification of a placement. So there was clearly some benefit recognised by the local authority to the ongoing relationship with the mother. And indeed, the mother's relationship with the older children was to be maintained, so they recognised a benefit even in long-term foster care. So whilst we say it's part of the thinking, we say that the significant part that the judge was focusing on was the sibling relationship. But when he turned to what the mother could still provide for these children, it's not the potential for care, it's what she can provide.
So what you're saying is ground 2 is misconceived because the judge wasn't refusing the placement order on the basis the mother could not be completely ruled out, but taking into account as part of his reasons for refusing the placement order the fact that it was important that the relationship with the mother continue.
Yes, because there was a benefit, there was a positive. And so when the judge says at the end, furthermore, the mother cannot be completely ruled out, he'd already ruled out the mother caring as one of the realistic options. He'd ruled that out because he said, mother can't care, I turn to the other realistic options, that's long-term foster care. Right, he identified 3 realistic options: care with the mother, long-term foster care for all 4, or a split, adoption and foster care. He then, in his judgment, makes it clear that care with the mother, the return to the natural family, is not a realistic option. He rules it out.
Okay, so he's not contradicting himself. When he says ruled out in 45, he means ruled out of the consideration or ruled out of the picture.
Yeah.
So I interrupted the lady.
Well, I was just about to say, so is your suggestion that the first sentence of paragraph 45 should be read with an emphasis on the word completely, i.e. she can't be completely ruled out of the picture, rather than, as I've already said, this is the judge, I've ruled her out of being in the picture for caring for the children.
Yes.
Yeah.
If he'd said completely disregarded,
So it's a bit ambiguous, but you say the right way of reading it is in that way.
yes, because if you look back at what he had said about her ability to care and what he'd said about her contact, the two are clearly distinct. So what he can only have been left with is the positives she could provide through contact.
In effect, the mother's relationship with the children and the effect that that has on their emotional stability means that she cannot be ruled out.
And that would sit, as my lord indicated, with what he says about ruling out the parental and sibling relationships.
Yeah, exactly. Then that fits with the rest of paragraph 45. Otherwise, one thinks that that first part of 45 ought actually to be a random paragraph on its own.
Yes, in essence, yes. And unless it's contextualised, perhaps within itself, it then becomes difficult to reconcile. Unless you do that, it becomes difficult to reconcile. Subject to obviously what we've set out in our submissions document in respect of the second ground, that's all I would propose to say about that particular ground.
I've got 2 points. Mm-hmm. Can I go back to the first ground?
Yes.
Something I ought to have mentioned, forgive me. In his citation from TNR at paragraph 43, if you've got TNR in front of you, in the bundle, we've got it twice. Haven't we? We've got it twice in the bundle.
I think we had it
twice.
And I think a new bundle should only have it once. I'm hoping.
Well, thank you for putting my judgment in twice. But it only needs to be decided once. The paragraphs he cites are 36 and 7, aren't they? I already pointed out that he omitted or the transcriber omitted the inverted commas because the second half, or most of 36, is a quote from the judge, what the judge said. What do you say to the suggestion? What would you say if I was to suggest that in fact he's taken that out of context, and the context of 36 and 37 is what I said at 35, and which led to the conclusions which I set out at 38 and 39.
Well, my lord, the context of 36 and 37, so my lord's paragraph 35 in the judgment.
Yes.
This is a case where the continuation of contact is a factor of particular importance.
Yeah, that's right. And I identified.
Indeed.
These are points Mr. Forbes, some of the points Mr. Forbes draws out in his written submission.
And, well, what we say on behalf of the mother is that is, of course, what the judge did. He considered that in this case, for all 4 children, but obviously with particular reference to H and A, the continuation of sibling and maternal contact was of significance for the children. That was the assessment that he came to on the basis of the evidence of their attachment as conceded by the local authority. So it's clearly right that the way that it's quoted in the judgment is inaccurate, because we can see from the proper law report how my lord has set out after para 112 already cited, and then we have the quote. But in any event, of course, what we would say is that the disadvantage of adoption is that there is no effective mechanism. Well, what the judge in our case did was he identified what the mechanisms were, section 26 and section 51. He put that alongside his assessment of the needs to maintain.
So where the case is on the spectrum, Mr. Forbes' spectrum, was a matter for the judge to determine.
Indeed, and he hasn't gone, we say, so far beyond what he was entitled to do with the evidence he'd had in writing, he'd had at the hearing, and of course his involvement in the case being long-standing. He was in a particularly advantageous position, having dealt with the first set of proceedings, refusing placement orders at the conclusion of those proceedings. He then revisits many of the issues. He had seen that sibling group develop, so he was well placed to assess, to his own knowledge from the evidence, his understanding of the issues, as to how significant that relationship was.
Thank you. If I may, my second point is, and I want to stress to the parents at the back that this is a hypothetical question, so we have to cover all the ground. But if we decide, having thought about it, that we think the judge was wrong on ground one, what do you say we should do? Otherwise, should we? Do you accept Mr. Sampson's submission that we're in the position to make the decision ourselves, as this court did in the DS case?
We would say that if the court is minded to take the view that the judge was wrong, ground one and ground two go to an analysis, or the failures of the judge go to his analysis of the evidence, the sibling attachment, the proposals of the local authority. We would say that it's not necessarily a case that this court is well placed or best placed to make those decisions.
What information do we not have that the judge that another judge would have?
Well, one issue, and there's a difficulty at the moment because, of course, the court did order amended care plans to be prepared by the local authority and filed, and we don't have those. Those haven't been filed by the local authority. They were due by the 30th of May. And so there are...
Those are amended care plans that reflect the judge's decision.
Yes.
Yes.
They should, indeed. And I fully accept that there is some difficulty in understanding the local authority's position about the issue of ongoing contact, because it's not readily clear from the judgment that the judge dealt with specifically how contact should be dealt with. And when one looks back at the care plans, some are silent as to sibling contact and
yes, they are,
and maternal contact. So there is an issue that hasn't properly been resolved going forward. So if anyone was to look at that filed care plan, filed on the children's file, it's not necessarily clear what that should say to reflect the judge's views. So there's that outstanding issue. But in terms of what further evidence there should be, the evidence is as the evidence stood before the court. So in that respect, the court can uphold the decision of the judge.
Yes, forgive me. If we're against, my question is, if we're against you, should we, and I stress it's if the parents aren't, if we haven't begun to talk about this yet or make our minds up, if we were against you and allowed the appeal, do you accept, as Mr. Sampson says, that this court is in a position to make the placement order subject to recitals, etc., or do you say the matter should go back to another judge to determine?
We would say that it should go back to another judge because there's been a change of local authority care plan in respect of L, which was before the original court, but much has been made of the issue of not having a placement identified, the known unknown, and how that may play, setting the tone for a placement to be identified. And so if the court does not take the view, as we put it, that the judge got it right, we say that then it should be remitted for reconsideration. because then if the local authority is saying that there is, as we say, a difficulty in making Section 26 orders when you haven't got a prospective adoptive placement available. We've heard today that there are over 100 who would consider it. The position of the court would actually be much better than His Honour Judge Weir had, which would be a proper family finding evidence as to whether there is a family that could in fact support what was required, namely His Honour Judge Weir's view about contact.
Wicks.
Sorry, Wicks, I apologise.
Looking back, thinking, oh dear, have I been reading the wrong judgment?
Judge Weir is.
I apologise. His Honour Judge Wicks. To have family finding evidence, a narrower pool, an understanding that of those chosen, identified, they would all accept contact. They would agree to an order if that was appropriate. That is the sort of evidence that the court would have, could have, should have, if it's going to be a case that this analysis isn't appropriate, hasn't been sufficient. Well, what is missing from this? Well, we would say there has to be the family finding evidence. It's been accepted by my learned friend that there are cases where that's necessary and appropriate. So if this court, my ladies and my lord, take the view that His Honour Judge
Wicks.
I will attempt to get it right in the course of the afternoon.
You anonymise the judge as well as
I think that's pretty sensible.
W.
His Honour Judge W. If the analysis is wrong, if it needs to be revisited, we say it should be done on proper evidence of family finding. That this local authority says to the court, well, we have families that will entertain contact. We're only looking for them, they say. Well, this is an opportunity for the court to...
Was this an objection raised below?
No,
In other words, was it an objection
No.
to the making of the placement order that there wasn't family finding evidence?
No, because
The position was the same. The local authority was asserting it would confine its search to those prospective adopters who would,
yes,
and also it would for a limit time.
yes.
Time.
Subject to what we looked at in the care plans and the final evidence, which was it would very much depend on any prospective adopters as to whether they would agree to it. But they were limiting their search both in time and in nature of placement.
Yes. Thank you.
And so one of the issues, as learned friend has pointed out, all are familiar with, there are cases where much more detailed and more specific evidence is required. And if the court does find fault with the judgment, we would say then the way to remedy the fault is to provide that detailed evidence, rather than assume that the making of a placement order, even with a Section 26 order today, would necessarily address the concerns that the trial judge raised and set out in his judgment.
Could I just say, one suggestion to the lady is that it would be helpful, I think, if we were to have, after the hearing today, draft orders reflecting each of your, I hope Mr. Forbes wouldn't be different from Mr. Sampson's, but with the local authority proposed order, if the appeal is allowed, and your proposed, well, if the appeal is dismissed, that's it, but your proposed order, if the appeal was allowed. So we could see, that would include for any recitals that anybody thought was appropriate, either way.
Yes, we'll
Is
liaise
that clear?
with that, of course.
You wouldn't have to do it today. Do it.
I'm both.
Thank you. I think that would be extremely helpful to all of us. I'm sorry, I didn't mean to stop you with that.
No, I'm finishing Millie's standing atticus.
Thank you very much indeed. So I think we're back to Mr. Sampson.
Lady, thank you. Briefly, firstly, a matter I perhaps should have raised first, but raised now rhetorically. What if this were a case in which the contact issue did not arise? I asked that rhetorically only for this reason, that the merits on welfare are overwhelming when one looks at everything outside the issue of contact, vis-a-vis the children's age, their placement needs, the absence of any specific issues with which they present. One then reintroduces the issue of contact and looks at the extent to which that should or does affect, and clearly it does, the welfare exercise. And the difficulty I have is the extent to which, on behalf of the local authority, the judge's welfare assessment, such as it is, outside the issue of contact, then shifts. And I won't go over the matters I have already, but do invite my lord and my ladies to look at that part of the judgment where he conducts the comparative analysis of the benefits of these two placements. Because what I say is notably missing is the sort of analysis that one might see looking at the welfare checklists under both acts and the way in which those would be met. And I say that because something that may assist my lords and my ladies, from the exchanges with Mr. Forbes on behalf of the Guardian is the starting point, if you like, of the extremely unusual / exceptional point. And within Re C, if I could take you, I'm sorry, to one of the tabs rather than the pagination, and looking at how, if you like, the ground has shifted. Page 8 of Re C, which is the last of the authorities in the bundle, contains not part of the decision, but instead is part of David Bodie's, as he then was, representations to the court on behalf of the official solicitor. Those begin, for the court's note, at page 6, halfway down the page. And it is interesting if one looks at the level of foresight in his address to the House of Lords. Page 8, because he was, of course, addressing a case in which the issue was contact between two siblings of some relevance here. And one sees there at Roman numeral 3, the point made, is there any distinction between an adopted child having contact with natural parents and having contact with other members of the natural family? There clearly is a distinction, but only one of degree. Condition of access inherently impinges on parental rights, but the impingement is more blatant where the access is in favour of natural parents. Natural brothers and sisters are in a different category. They do not have the catalogue of parental rights over the child taken away from them. In their case, the relationship is a human one. And that, frankly, is the issue with which my lord and my ladies are grappling here. The carrying forward of an existing biological relationship that is capable actually of supporting a child, not only through their minority, but beyond. Within that case, in fact, it was agreed that contact would take place. The issue in this case was, of course, whether it would affect the dynamic of that relationship in a way that militated against the making of an adoption order. And if one looks just below F, contact by the child with her brother M is envisaged in any event. The suggestion that adoption with a condition of access will store up trouble for the future is illusory. Greatly preferable for the child that contact with her brother should take place. And I make this point because it goes to this case. From a stable background, with her status secured as a full member of the adopter's family, one needs only to look at some of the subsequent case law to see that point made again. The position or environment from which the child accesses contact is relevant when the court looks at contact itself.
Distinguished as Mr. Justice Bodie, as he became, this was a submission rather.
It was, and I'm looking, if I'm being my lord, and I'm sorry to take too long on this, I probably am.
But is there a passage in the judgment, or you can decide in support of that?
Yes, the issues that I just wanted to flag up then is the speech of Lord Bridge of Harwich, and that starts at the bottom of page 9. Sorry, forgive me, Lord Ackner.
Lord Ackner, I think.
Forgive me. And it is page 11, first paragraph. It was common ground at the hearing of the adoption application that there existed a worthwhile relationship between C and M, which was in the interest of C to continue. The appellants gave evidence confirming acceptance of this fact, willingness that relationship between brother and sister should continue after adoption. Mrs. B, the natural mother, however, withheld her consent to an adoption on the basis that that would weaken the relationship. There is then a review of the case law prior to that time. Of course, that was at a time where
Well, the whole question of consent was a different legal regime.
Well, adoption wasn't even designated as family proceedings, from my understanding. So at that point in time,
You're right.
it would have been under the 1976 Act.
76 action.
Not sure.
And with withholding and dispensing with consent, there was a different test.
Yes.
Which you're too young to remember, Mr. Sampson.
But, my lord, I raise it because, of course, there is some review of how this was then dealt in previous cases. It's probably of tangential interest to this case, but I did want to draw out one aspect of that, which is in a review of the existing case law, a decision by Mr. Justice Reed and Reed J in 1973, which is at the bottom of 13.
That's even longer than I can remember, Mr. Sampson. I mean, 50-year-old authorities are in this area are not necessarily going to help us, I think.
No, the only point that I was going to raise is this, that not only have matters moved on, but even prior, if you like, to this decision, there were cases in which directions had been made for contact through the prism again, of how adoption was viewed at that point in time. But bluntly, the main point comes at the bottom of page 17. It's an area highlighted already by Mr. Forbes. And it's just one phrase that I wanted to draw out because it goes, of course, to my Lord's decision in 2021. It's at page 17, G. The cases rightly stress that in normal circumstances it is desirable that there should be a complete break, but each case has to be considered on its own particular facts. No doubt the court will not. And it's that first phrase that is sometimes missed, because one looks at exceptionality, highly unusual. But at the very start, if you like, of this line of case law, there is the caveat that we raise again today, which is that these are fact-based decisions. I promised, my ladies and my lord, that I would at least provide you with some overview of how many cases, Mr. Forbes having rightly noted, that certainly in Re P, the adopters, of course, were not known, of how many of the cases they haven't been. And if I may, a whistle-stop tour only in this way to give my lord and my ladies an example of it. One has quoted in those, or cited in those authorities, a decision by Lady Justice Butler Sloss in '95. That was a case in which the mother was seeking contact 2 to 3 times a year. The adopters were saying once the mother's application was refused, the adopters were therefore known. In Re T, a decision the same year by Lord Justice Balcombe, the adopters were known. In 2005, 4 months before the implementation of the Adoption of Children Act in Re R, the adopters' views were known. In Oxfordshire County Council X, Y and J, a decision from His Honour Judge Corrie, the child was already subject to an adoption order which he'd made a few months before, and contact was then being looked at. And Re B, of course, in that case, the views of the adopters were known. I only raise that to draw out that in the majority of this case law, the views of the adopters are already known. The only other points I wanted to raise, if I may, are these. The first is that you have rightly been taken by my learned friends for the mother to the basis on which this court should interfere with the decision. And that's the point that's been made again orally today. Could I invite my lord and my ladies to look at paragraph 14 of DS, which is at 120 of the appeal. And in very briefly, because there are 2 paragraphs there that go to the 2 issues that I want to address you on, the first of which is when the Court of Appeal should interfere with the decision, paragraph 14. And it's a very pithy summary of the existing case law, but both Piglioska and others. Halfway through 14, we will not allow appeal just because we think there might have been another possible plan which would have been better. We can only step in if it had been shown the judge did not approach the decision A, correctly, B, explain it properly, or C, if the judge's chosen plan will not work. I say all 3 of those on the arguments that we advance are made out. My lord has already exchanged or had some discussion with Mr. Novoloni about whether or not the judge's citation of your decision some 3 years ago was only partial, and I believe, but I just want to check that my lord made the point that I was going to draw out, which is the way it is set out in the judgment does not distinguish between my lord's observation and then a quote from the judgment itself that my lord was dealing with in passing. I raised
Well,
it because it's quite.
It omits the inverted commas, which really make it clear. It didn't, as I was reading it, it didn't sound like me, and sure enough, it's the quote.
Yes. Well, there is perhaps only to some extent, but there is some importance in that. Because if one looks at the bit that has been quoted in that way, the part that's taken, forgive me for moving to it very quickly, is at paragraph yes, it's paragraph 36 and 37.
It is.
Well, the quote is at 36.
Yep.
And, my lord, in fact, if you go back, it may have been that this was the exchange, and forgive me if I missed this. 35 is where it starts, because my lord...
Yes. No, my point, I was making 2 points to Mr. Murray. The first was that the passage in the second part of 36 that begins the disadvantage of adoption, that and the rest of the paragraph is a citation from Judge Richards' judgment, the first instance. It wasn't me, it was me, it was the judge. The second point is, I was put to Mr. Nobley that paragraphs 36 and 37 have to be seen in the context of paragraph 35 and the conclusions of paragraph 38 and 39. I don't suppose you would disagree with that.
My lord, I don't disagree with it, and in fact that last point my lord makes features in 38 of the judgment, where my lord is not saying, well, this is an application of any universal principle upon rights. Rather, it is simply a decision to which that learned judge was entitled to come on the facts of that case, those facts being set out in some detail in that summary that my lord gives at 35, which arguably is a crucial paragraph because it is the preface to the entirety of the logic that follows. My ladies, my lord, the only other point is found, of course, in paragraph 50 of the decision of Lord Justice Peter Jackson, and it goes to the question of relief on the appeal, if my ladies and my lord permit it. And in that case,
That was paragraph
15.
15.
115 at 120.
Yeah, and he says, is the evidence complete? Is there any one answer?
Exactly. The position put before this court on behalf of the mother today does not in any way reflect the position that was advanced before the court at first instance. No further evidence was sought vis-à-vis family finding, timescales, identity of adopters, willingness to entertain contact. No further evidence was sought as to how the local authority were the mother to wish to have contact, as I have little doubt she does, with the younger children, to maintain those children in foster care that will be implemented. No position was advanced that a Section 26 order should be made to provide for the mother's contact. All of those matters are new. This is an appeal. It is not the proper forum in which alternative cases are now run, further disclosure is sought, further evidence required. And the resulting delay, and I must raise that, is one that we have a very clear eye to. These are, with no criticism either of the parties or indeed of the judge, these are proceedings which have now had 2 incarnations. And we say that this court is in a position, if not in this case then, to provide its own assessment on the welfare checklist that's required. What of course I didn't say, and perhaps should, is it is a matter for this court whether it takes the view, having looked at the way in which that was dealt with by Lord Justice Peter Jackson in DS, to make a Section 26 order. As my lord and my ladies know, that was not the local authority's primary contention. It was, if you like, introduced by those on behalf of the children as a way in which the judge's uncertainty could be shored up.
But what's your position on that?
My lord, my ladies, I accept that it is something that in the circumstances of this case, where there is quite clearly an established relationship that is a support to the children moving forward, then this would be an appropriate case. I raise it only for this reason, that I cannot ignore that the no order principle still applies. And it's the point that was drawn out by Mr. Goodwin and Ms. Collinson in the skeleton argument, that the recitals to the order, a matter that both I and others have addressed this court on today, but also the judgment of this court as something that the local authority then works with prospective adopters on, is something that is an alternative. But I do not seek to go behind the suggestion that a Section 26 order could be made by this court and offer no active opposition to it whatsoever.
Perhaps in your draft of orders, you'd include that in square brackets then,
Yes,
as an option.
one matter that I believe my lady raised earlier about how the judge approached the care planning with Mr. Nuvoloni, I am told by Miss Collinson from her note, and it may help, because there was some shift in the evidence, some, as I put it earlier, cementing of certain issues. The judge asked a question of the social worker, are you ruling out adopters who would rule out contact? To which the response was, absolutely. And that is something which in some shape or form would find its, or will find its way, into the proposed final care plans. Forgive me, may I just again turn my back? My lord, I'm conscious I've been on my feet more than others. I simply, having discussed it with Mr. Collinson, on instructions from the team voicing real concern about this case going back, I suppose the best I can do is to invite my ladies, my lord, to look back at Re-DS and see how that was dealt with in a rather robust way that Lord Justice Peter Jackson does when looking at, well, what further evidence was required. This, as an issue of principle, is a question of a local authority being entrusted, whether with a Section 26 order or not, to find adopters. There is relief that is available to the mothers to seek a Section 26 order in addition. I appreciate that the Achilles heel there for me is, of course, that we are dealing with inter-sibling contact rather than parental on this appeal. But I do query whether or not that further evidence is something that is necessary in this case.
Thank you.
May I assist any further?
You haven't said anything in reply to Mr. Nuvoloni's submissions on ground 2,
Yes.
which, if I may say for my part, seemed to me to be cogent. That the judge's initial few words at the start of the last paragraph don't, in fact, on which your ground 2 relies, don't in fact reflect what he's talking about in the last paragraph, which is about the ongoing relationship rather than the prospect of the children going back to mother.
As I said earlier to this call, I think using that figurative speech of looking through a glass darkly, it is a little hard to divine what exactly the judge did have in mind. Perhaps the best way in which I can deal with it is to look first actually at 44, because it carries forward. If my lord looks at paragraph 44, that brings into play. The first few lines of that are the balancing. There is then that phrase that Mr. Forbes addressed this court on, the right of permanency comes close to social engineering. I respectfully and entirely agree with the submission he puts to the court. One queries what that means. The role of the court is to protect children from harm. My lord raised what that meant. And of course, the best I can do, perhaps, is this. The role of the court is to protect children from harm insofar as when it's dealing with the Children Act application for a care order, it looks at threshold, and if that hurdle is crossed, it then looks at welfare. And it looks at part of that as the risk of further harm in the future. But of course, this judge was, at this point in the case, dealing not just with the care application, but also with the placement order application. And if I may say so, that is not the role of the court. The role of the court is to conduct a welfare analysis of the children's future options. And to look at
It's a great advocate's technique to argue a different point from the one that was raised, Mr. Sampson. I was actually asking you about the first sentence of paragraph. Well, your ground of appeal is The learned judge was wrong to refuse the placement orders on the basis the mother could not be completely ruled out.
Well,
Mr. Nuvoloni has sought to demonstrate, in my view at the moment, not unconvincingly, that wasn't what the judge was saying. And on a careful reading of 45, he isn't ruling out the placement order on the basis the mother could not be completely ruled out as a carer, but rather taking into account the fact that the ongoing relationship was important.
my lord, I'm not sure I either disagree with that or have to disagree with it. And forgive me for testing this court's patience. The reason I went back is that it is quite hard to understand the line of logic, but doing the best I can, if one reads on from where I just reached, what it says is this: I have to consider, it's not to improve their life chances or to move them to placements where they will be better off. Well, I'll pass over that, but it goes on, I have to consider their lifelong welfare. In that context, sibling relationship assumes a critical importance. And that's the phrase that features large elsewhere. Its maintenance simply cannot be guaranteed in adoption, certainly not to any meaningful level. And then it reads on. Furthermore, the mother cannot be completely ruled out. At present, the risk to the children of a return to her care are simply too great. Certainly that phrase taken by
It goes
itself,
on.
and then it goes on, certainly that phrase taken by itself would suggest that he might be thinking, as he moves on, about...
Okay. But thereafter, it's all about the continuing relationship, not resumption of care, isn't it? It's about much. He's got much to offer. And then he outweighed by the loss of the sibling and parental relationship. And he makes that point twice.
Yes.
Preservation of sibling and parental bonds.
It is... My lord, I understand the point. The difficulty I have, I suppose, is that one is grasping or stretching to try to find out what the learned judge did mean. Because surely, I ask rhetorically, if he had been intending to preserve that relationship through ongoing maternal contact, then there would be at least something in the judgment that indicated that he had that in mind. It wasn't, in fact, an issue that was explored in evidence. It wasn't something that the local authority was asked either under Section 34, with the care order, or under Section 26, where the placement order to have been made, to reassure the court about. So the difficulty I have with moving that into this being about contact is, if that construction of paragraph 45 is right, where else do we see it in the judgment? Where else is there any consideration of ongoing contact? The answer to which is there isn't.
I mean, it is couched there, essentially, that paragraph, in terms of the relationship. So it's a 1-4F point, isn't it?
Yes. If one looks back at the ground of appeal, I suppose.
Yeah, your ground of appeal would cover that point as well.
It works both ways. Yes,
It does.
Precisely. So I'm not.
So you say that even if Mr. Navarone is right about the interpretation of paragraph 45, the judge was still wrong to take it into. The judge was wrong to take it into account, to refuse placement order on that basis.
Yes, I've already made the points on the fact that it flies in the face of the judge's earlier analysis about the mother's abilities. But there is, of course, also the issue that I raised earlier, which is, if referring back, and I could do no better, to the decision of Lord Justice Peter Jackson, one of the points is that it's not been explained properly. It's not clear what he meant by that at all, at the very best.
Sorry.
Yeah.
After you.
What I was going to suggest is that if the passage is ambiguous, aren't we on appeal bound to give it the construction which is most favourable to the judge?
Yes, my lady, if I may, I entirely agree. And that's why my Lord Justice Baker, I suspect, had the answer or the question to me, well, if he means contact rather than the possibility of rehabilitation, and what's your response to that? To which the answer is, it doesn't really matter whether it was one or the other.
Point, yeah.
And the other point I think you're making is there's nothing else in the judgment about contact with the mother, and it wasn't trailed before the judge in evidence at all. Okay.
It would be, in a case where a local authority was saying no contact, in a case where there, a farewell contact and then no contact as between the two younger children and their mother, it is inevitable that there would need to be a litigation of that issue, exploration of it in evidence, and frankly, given the local authority's stance, orders sought to ensure that that contact did take place where the local authority was saying no. None of that is in there, and in any event, none of it is covered in the judgment.
Thank you very much indeed. Thank you to all of you for your careful and helpful submissions. Thank you to everyone behind who's no doubt done a great deal of work. This is a very sensitive and important case, and on that basis, we won't be making decisions today, and we'll be considering everything very carefully. But we will be trying to deal with this as soon as possible, because of course it's very important that there's not further delay from the point of view of the children, but from the point of view of everyone involved, including the parents who've been present here today. So we will do our very best to deal with this as soon as we can. You all know how things proceed in this court, which is that when there are judgments or a judgment, it will be handed around in draft. It's particularly important that only those who are on the list, which have already been given, hopefully, to our clerks, receive that draft judgment, because it will be subject to the embargo. The embargo is very important. We encourage and hope for and expect corrections on the basis of typographical errors and obvious mistakes, but no re-argument. Thank you so much. We also expect you to be able to either agree an order or put together very short submissions in writing in relation to consequential orders. But in any event, that is partly overridden by only partly, by what my Lord Justice Baker has said, that we would be grateful to see your alternative drafts, win or lose, and with any appropriate recitals that you think should be in them. And in relation to that, although it hasn't been set, I'm going to set a deadline for you in relation to those, so that we have them all to consider together, of 4 p.m. on Monday. Is that doable? There's some nodding behind you, Mr. Sampson.
No, I am thinking only of this further to the exchanges earlier. Ms. Collinson and I have spoken again with the team. I anticipate it will be of assistance to you to have the care plans about which we spoke, i.e. those which incorporate the amendments that were made to the care plan during evidence. And I was only thinking of the sequence in this way. If those care plans were, because we will need to get approval of those, which is already given orally, it's simply a matter of ticking that box.
So you want longer than that, but how long do you want?
7 days for the care plans, 10 days for the orders. But if it would assist to have them sooner, if I can turn my back.
Excuse me. Care plan. But that's a long time. I think it will be done in 7 days. Yes, I'm happy. So deadline, I think that's it. Yeah. So deadline at 4 p.m. next Friday. 2 p.m. next Friday. Okay, happy?
Yeah, I'd have to go to somebody else. I'd work as my client now.
Yeah.
Get the care plans, John.
None of them know.
So you'll have to go to Dollar Tuesday.
Should be right. Sorry for all that whispering. We would like, therefore, your alternative orders and the amended care plans and I'm sorry not to have also involved my Lady Justice Laing in that, by 2 p.m. and next Friday. So that is, in effect, 7 days. And I haven't worked out what date it is next Friday. 13th? Friday the 13th at 2 p.m. And because it's the vacation, there'll be issues about who to send it to. And we've concluded that it's best, in the first place, that it's sent to Lord Justice Moylan's clerk, who will then be able to send it on to the appropriate places. Does that cover everything that we need to cover, ladies and gentlemen?
Thank you.
So, thank you very much indeed. Thank you.
4 grounds of illegal.